Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, 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 Sherry, John. You got here before it even started. So you're in great stead, John. I heard all of you talking about, my schedule is almost as chaotic as I am. I mean, really. Nothing can be quite as chaotic as I am, but my schedule comes a close second. As some of you may remember, this weekend is a long weekend in Canada, but celebrating Canada Day, celebrating Victoria Day. I live in Victoria, but it's not about celebrating our town. It is about celebrating the Queen. The former Queen? I don't know. The dead one. One of the dead ones. They're all dead, right? Now I hear people in my house. Grant me some serenity, people. So help me God. I hope everybody's doing great. Tell me what you had for breakfast, lunch. What time is it? It's 2 o'clock. That means it's 5 o'clock East. So tell me what you're having for dinner. I am not hungry yet because I made breakfast burritos for breakfast. Also, I did my nails. How cute do they look? Oh my god, they're so cute. And I think they match some part of this part of the dress. Oh, it's like bang on. Look at that. I love it. You were doing something and then my voice just came out of nowhere. That is a perfect problem to have, William. Thanks for tuning in. If you are just tuning in, let's get going. Sausage, egg, avocado, and pineapple. You know what pineapple's good for, right? Do we know what pineapple is good for, Night Wolf? I'll give you a hint. It could put a glint in your woman's eyes. Oh, we cracked our voice there. Apparently it makes your semen taste good. Educational channel, bro. Educational channel. Oh, all the swingers know about my house. Don't you worry about that. Fuck. Anyways, okay. Let's get to it. It's this one here. Yeah, mango flavored. Those mango terpenes. Good. Why can't I find the button? The button that I need. Here is the button. Huh?
Mr. Adamore. Okay. All right.
I already took it off.
Okay, can you raise your right hand for me? Do you solemnly swear or affirm
Yes,
that the testimony you're about to give in this cause, sir, I can't see you again, will be the truth, the whole truth, and nothing but the truth?
1 second, I gotta step outside. I'm so sorry.
That's okay, sir.
What about you? Go sit down.
Okay, I'm ready. Sorry about that.
Okay. Now, I'm gonna have to ask you to raise your right hand again so I can swear you because I couldn't see you and I couldn't hear you if you answered. Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may lower your hand, and Ms. Peoples, you may proceed. Mrs. Doty was previously sworn.
Thank you, Judge. Judge, on this case, the previous order also had your name in the short signature block. You did not sign the order. It was signed by Robert Maxfield.
So, Mr. Adamore and Ms. Doty, Mrs. Peoples is bringing that up because at some point in time, I worked for the Attorney General's office. I worked in the office that handled your case, but I do not remember either one of you. I did not work that case. And so, but if either one of you is not comfortable with me handling this, I will refer it to one of my colleagues. So first, I'll ask you, Mr. Adamore, are you okay with me hearing this matter?
Yes, ma'am.
Okay, and Ms. Doty?
Yes, ma'am.
All right. Then Ms. Peoples, you may proceed.
Thank you, Judge. We're here on an order in suit affecting the parent-child relationship and suit for modification and to confirm arrears. Judge,
Mom.
parties agree to all issues except for they are
Not
requesting
yet.
deviation of the child support.
Okay.
So, Judge, there are two children before the court, Armani Adamore and Amari Adamore. There were previous orders on the child.
No, 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 no. Absolutely fucking not. They named their kid Money? I didn't know that. Oh my god. Do you think it's spelt with a $sign or do you think it's spelt money? Grant me some serenity today. I can't handle this.
Okay.
So, Judge, there are two children before the court, Armani Adamore and Amari Adamore.
Our money? Our money? Am I mistaking that? Is she trying to say Armani? Oh my god. Regardless of what she's saying.
Deviation of the child support.
Okay.
So, Judge, there are two children before the court, Armani Adamore and Amari Adamore. There were previous orders on the child, Armani. So I'd offer as State's Exhibit A, the acknowledgement of paternity for the child, Amari Adamore.
State's Exhibit A is admitted.
Thank you, Judge. Parties agreed to be appointed as joint managing conservators of both of the children, with the mother having the right to determine the residence within Dallas or any contiguous counties. Parties agreed to a standard possession and access schedule. Judge, the mother is not requesting any retroactive child support for the child, Amari. And Judge, she is in agreement to release all of the child support arrears that are previously owed. So the child support judgment after release would be $0. That's as of May 15th, 2025. As far as the medical arrears, there's no request for retroactive medical for the child, Amari. There's also going to be a release of some of the medical arrears. So the medical support judgment after release is $4,293.24. Also, as of May 15th, 2025, Mr. Adamore is to pay that at $72 a month beginning June 1st, 2025. As far as the modification, Judge, there are two children before the court. Mr. Adamore does have another child for which he's obligated to pay support. Parties are in agreement that the health insurance will be provided, the medical and dental insurance will be provided by Mr. Adamore through his employer. And Judge, the child support, which is not agreed to for the two children, would be $243 a month. Court costs would be as billed to Mr. Adamore. There's no request for non-disclosures, and that's the extent of the order.
And what is the child support again?
It would be $243 a month.
Thank you.
If I could call the mother, Miss Doty, if you can unmute and state your name.
Nicole Doty.
And Miss Doty, did you hear all the terms of the order that were stated to the court?
Yes, ma'am.
Okay. Let's start with, well, with the exception of the child support,
I don't want to get him in trouble, but that's a Waffle House lanyard around his neck. No wonder it was busy, sounding as heck. Seriously, but I love a Waffle House. Ate there a few times on my trip to America a couple years ago. Always a good time. Seriously, there's no joke there. That's just fucking true.
you understand all the other terms that were stated, is that correct?
Yes, ma'am.
Okay. And you're in agreement with all those other terms?
Yes, ma'am.
Okay. And you understand Mr. Adamore does owe some child support arrears on your case, correct?
Yes, ma'am.
Okay. And you are in agreement to release all of those arrears, which is a total of $19,971.40 in child support arrears.
Yes, ma'am.
And you're releasing those arrears on your own free will?
Yes, ma'am.
You understand once you release those arrears, you won't be able to get them back?
Yes, ma'am.
And so you're in agreement to a $0 child support judgment after release?
Yes, ma'am.
And for the medical arrears, you're also in agreement to release some of those as well?
Yes, ma'am.
And you are in agreement to release today $1,393.77 in medical arrears?
Yes, ma'am.
And you're doing that on your own free will?
Yes.
And you understand once that amount is released, you won't be able to get it back?
Yes, ma'am.
And so you're in agreement to a medical judgment after release of $4,293.24?
Yes, ma'am.
And you agree Mr. Adamore would be ordered to pay that at $72 a month beginning June 1st?
Yes, ma'am.
And then as far as the child support is concerned, you understand based on his income and giving him credit for his other child, his child support obligation would be $243 a month. Do you understand that?
Yes, ma'am.
And you disagree with the 243?
Yes, ma'am.
How much are you requesting he be ordered to pay for support?
Oh, wait. No, mind. Yeah, I agree to that.
You are in agreement with the child support of $243 a month?
Yes, ma'am.
I'll pass the witness, Judge.
You may call your next witness before you do. Mr. Adamore, you have been walking through this whole hearing. If we were in court, you would not be able to walk like that. I need you to get somewhere and be stationary. When you move around, it distorts the sound and it makes me dizzy.
I got you. I'm just at work right now. Just gotta go check on my cousins and I'll just walk back over here.
Okay,
I'm
well,
good though.
all right. Thank you, sir. Go ahead, Ms. Peoples.
Thank you, Judge. Mr. Adamore, can you state your full name?
William Anthony Adamore.
And did you hear all the terms of the order that were just stated to the court?
Yes, ma'am.
Did you understand all of those terms?
Yes.
With the exception of the child support for 243, you agree with all the other terms and believe they're in the best interest of your children?
I thought I was getting took off, so I didn't think, I remember you saying if the
Okay.
judge
Hold on,
wants to do the
hold on, Mr.
243.
Adamore. We're going to get to the child support. The question is every other term of the order. Do you agree to all the other terms of the court order?
Yes, I agree with that.
And then as far as the child support, you understand that your income, based on your income, the child support for the two children would be $243 a month. You understand that?
Yes.
Okay. But you are requesting that the court not order any child support today?
Yes.
Okay. Can you tell the judge why?
Because the last couple of years, all that back child support I owed, we was together, and I was taking care of my both of my kids. We just never went to court and finalized me getting off of child support. We just broke up after 10 years just last year, and I was with her the whole time, taking care of Armani. And I was
Okay.
paying for her to eat, to sleep. We were staying in the same house. I was paying light bill and everything, rent.
Okay, so Mr. Adamore, you understand that Ms. Doty, she agreed to release the arrears that you owe for the previous obligation. You understand
Yeah.
that, right?
Yeah.
Okay, so going forward, you would have a child support obligation beginning June 1st of $243. Why do you disagree with paying that amount going forward?
Right, so no, but I'm
Uh,
not a
Miss Doty, not your turn, ma'am. You're just talking
Okay.
to Mr. Adamore right now.
Okay, this is what I'm not understanding. Well, what I'm gonna be paying $243 for, I'm not understanding that. If I'm
Mr.
being
Adamore, you understand that you don't live in the house anymore?
Yeah,
Okay, and you understand that the children still have needs? You took care of them then, and she released all of that money. Now
Uh.
we're going forward, and so now you need to contribute to their support going forward.
Okay,
Now, do you understand?
I understand.
Okay, go ahead, Ms. Peoples.
Judge, I'll pass the witness. I think I need to recall Miss Doty.
Okay. Go ahead.
And so Ms. Doty, just you understand that the proposed order sets the child support at $243 a month. Are you in agreement with that?
Ms.
no,
Doty,
ma'am. No, ma'am. That's why I thought I was taking him off.
So you're also requesting the child support be set to $0 a month?
Yes, ma'am.
And why are you asking the court not to order court order child support?
Because we came to an agreement, like because he been taking care of them, and like we came to an agreement that we don't need child support no more.
I'll pass the witness, Judge.
okay.
You finished?
Then I will accept the agreement of the parties, make this agreement the order of the court, except for child support. I will order child support at $243 per month. All start dates will be June 1st, 2025. Ms. Doty, Mr. Adamore, I know you guys have an agreement today, and I appreciate you co-parenting. I think you should continue to co-parent, but my job is to do what's in the best interest of your children, not ratify your agreements. And I feel like it's in the best interest of your children to have child support ordered so that at any time your agreement falls apart, your children will have something to rely on. Ms. Doty, if you don't need the $243, you can give it back to him every month. But I am going to order it. Do either one of you have any questions?
No, ma'am.
Okay, now that now, I'm not the last word on this. You have 3 days to appeal, 30 days to file a motion for new trial. This is out of the 303rd District Court. That is Judge Laditra Atkins. She might have a different opinion from mine. Now that I've given you that information, do either one of you have any questions? You're muted, Ms. Doty, if you're saying something.
Oh, no, ma'am.
Mr. Adamore, do you have any questions? Mr. Adamore,
He muted.
do you have any questions, sir?
No, I don't.
Okay, then thank you both for appearing here today, and you're both free to go.
Okay.
Dang, they didn't seem so happy about that one.
Judge, I
Winter
need to do a
Witch.
couple of room assignments, and then after that,
Shut up, sir. I'm in charge here. I decide what happens. Winter Witch came in, paying me lovely compliments. Don't worry. Just 20 minutes before we went live, I also was still in my pajamas. And my kitchen is a bigger mess than you could ever believe. Ever believe, I promise you that. But we'll skip ahead to this.
We're hearing cause number DF 21-15342, Crook and Knave, with the parties in the Crook and Knave matter Please unmute yourselves, turn your cameras on, and raise your right hands. Do each of you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Mr. Cook
Yes.
and Ms. Nave,
Yes.
you may both lower your hands. And Mr. Talley, you may proceed.
Thank you, Judge. We are here on a notice of change status. If I could, before stating the terms of any proposed order, I'd like to offer into evidence what's been marked for identification purposes as State's Exhibit A. It is a copy of correspondence between me and a caseworker from the Department of Family Protective Services regarding an investigation concerning the children in this case.
State's Exhibit A is admitted.
Thank you, Judge. I do not want to share it based on the sensitive nature of it. The court might want to review it before we proceed, as it will explain the proposed order and some of the testimony, or would you just like for me to proceed?
You may proceed, Mr. Talley.
Okay. It has been emailed to you directly if you'd like to look at it.
Yes, I got the email.
Okay, thank you, Judge. May I proceed stating the proposed terms?
You may.
The order would name Mr. Crook as the managing conservator of the children and Ms. Nave as the possessory conservator, with Mr. Crook being the conservator with the exclusive right to designate the primary residence of the children within Dallas or any contiguous county. There is a finding that there has been a history or pattern of family violence on the part of Ms. Nave within 2 years, and a finding that her having access to the children would not endanger their physical or emotional welfare so long as her possession and access is supervised. And then the visitation would be from 11 a.m. to 1 p.m. on the first, third, and fifth Saturday of each month, with those periods of visitation to be supervised by Mr. Crook or an individual who designates at the McDonald's located on Preston Road in Dallas or any other mutually agreed upon location. Mr. Crook would be ordered to apply for or maintain the children on the government medical assistance program. Ms. Nave would be ordered to pay cash medical support of $50 per month beginning June 1st and guideline child support of $275 per month beginning June 1st.
275?
Yes, Judge.
And 50, correct?
Yes, Judge.
Okay, thank you.
The order contains a child support judgment against Mr. Crook after a possession credit is applied in the amount of $6,456.76. That is as of May 15th. That judgment would be payable at $60 per month beginning June 1st. There's also a medical support judgment against Mr. Crook after the same possession credit is applied in the amount of $2,141.19. That judgment would be payable at $35 per month beginning June 1st. And that possession credit is for the time period from June 2024 through May of 2025. Court costs would be as billed to Ms. Nave. There would be a finding of non-disclosures that pertains to Mr. Crook's address and other identifying information. As the extent of the proposed order, if I may call the parties.
You may.
I'll call the father. Sir, would you please state your full name?
Antarius Crook.
And in June of 2024, there was an incident concerning Ms. Nave and the children, which prompted a CPS investigation to begin. Is that correct?
Yes.
Okay. And at that time, the children were removed from Ms. Nave's possession and placed with you. Is that correct?
Yes.
And they have been with you since that time. Is that correct?
Yes. Yes.
Now, part of the exhibit that was entered into evidence previously, is it your understanding there was a finding on the part of the department that Ms. Nave was responsible for neglectful supervision of the children?
Yes.
And it's your understanding that the children, based on that finding, are to remain with you, correct?
Yes.
Are you asking that any visitation that Ms. Nave have be supervised as a result of those findings?
Yes.
And are you asking that you or someone that you designate be responsible for the supervision?
Yes.
Is there anyone in her family that you would be comfortable doing the supervision?
Her mom.
Her mom?
Yes.
Okay. What is her name? Do you know?
Like I just call her Miss McCoy.
Okay. Have you participated in services with the Department of Family Protective Services?
No, I know they came to my house and like pretty much like making sure everything is okay with the
Well,
children.
that's what I mean. You are continuing to be
Yes.
engaged with them.
Yes.
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 Okay. To your knowledge, has Miss Nave engaged in any of those services?
No.
Okay.
So in the state of Texas, if your children are removed by CPS, you follow a very prescribed route to get your child back. It goes through the courts. You have to engage in services. You have to bend over backwards and do what the courts want. And you have 1 year to do that, or they will permanently remove your children from your care. We're going to hear her reasoning coming up. Don't worry, she doesn't not talk. She explains it, you guys. She explains it. And let's see if we buy what she is selling.
Due to the incident that was back in June of 2024, are you also asking that the court make a finding that there's been a pattern of family violence on the part of Miss Nave?
Yes.
And due to the fact that you're requesting the visitations occur at a neutral location, are you also asking that the court make a finding of non-disclosure so that your address and other
Yes.
identifying information are not included in today's order?
Yes. Yes.
You heard all of the terms that I stated to the court, correct?
Yes.
And you understand all of them?
Yes, sir.
And you believe the court entering that order as stated would be in the best interest of your children?
Yes.
I'll pass the witness, Judge.
You may call your next witness.
I'll call Ms. Nave. Ma'am, would you please state your full name?
Sydney Nave.
Did you hear the terms of the proposed order that I stated to the court?
Yes.
Do you understand those terms?
Yes.
And you are not in agreement with any of the terms of the order, is that correct?
No.
Okay. So you are asking that you remain the person that has the right to determine the primary residence of the children, and that Mr. Crook be ordered to continue paying child support. Is that correct?
Yes.
Okay. Is it true that the children have not been residing with you since the incident of June of 2024?
Yes.
Okay. Please tell the court why you believe it is in the children's best interest for you to remain their primary conservator.
I believe that the finding that I talked to you earlier was the first time I'm hearing about it. I've been calling for months to get information. Nobody has not talked to me. This is the first time that I even got anything from anybody. So, and I don't believe in their findings. They didn't do any investigation. I only talked to one person one time since the whole thing started. So I'm confused pretty much. And,
Okay.
and I don't even know what it's based off of.
So in June of 2024, the children were removed from your custody by CPS, correct?
Yes.
Okay. Have you made any attempt to have the children returned to you?
Yes. And I talked to only one person from, I think either the what is it, either the CPS or the DF, the
Same
other
thing.
one.
The same
Okay.
thing.
I only talked to one person one time. That's it. And I've been calling for months trying to get information.
Who are you calling? 411? Who the fuck? In what world do you not engage with the services and figure out, like, you would have a caseworker. If they remove your children, you get a caseworker. Is her shirt all the way off now, by the way? Like, if we pan down, would we be getting breastises? It sounds to me like she gave up, and they placed the children with a parent who was not giving up, who was willing to subject themselves to the situation. And we're gonna hear here, they didn't get taken away from the house. Let's see.
And trying to get any type of documentation, and today is the first time I even got the documentation that you sent me.
The documentation that I sent you was entered into evidence earlier, and it includes a statement from the CPS investigator that you have not cooperated and participated in the services with them. You dispute that?
Yes, I do dispute that. I never talked to anyone, so I can't even defend myself. They don't even know my story.
This one conversation you had with them, so the incident occurred on June 12th. Was the conversation on that date or close to it?
No.
Okay, when did you actually speak to someone from CPS?
It was July. Hold on. I have it written down somewhere. It was in July. It was the first time I actually talked to somebody since the incident. And then even after that, I didn't talk to nobody else. And I was calling.
Were the children removed at that time when you had that conversation, or did it occur prior?
No, they were removed at the hospital.
Okay, and then you had a conversation with someone from CPS later. Okay.
Yes. And that was it.
Okay.
So they never did any investigation.
Okay. Is there anything else that you'd like to tell the judge?
Like I said, they didn't do any investigation. I've been in constant contact with the detective down in Houston, but that was about.
Oh my God. Wrong answer, wrong answer, wrong answer, right, Dogman? Like, this is the thing. This is the... And we know this because we watch these cases. So you're telling me that they removed the children from your care and then a month later you called. It's hard to show less interest, honestly. Sometimes we have parents. I used to watch a lot more CPS court. I don't as much anymore. There are other channels that are dedicated to getting that, and I love that. But it just means I dedicate my time to other courts. But I remember I used to watch a lot of CPS court in Texas. And, sometimes parents were frantic. Like, frantic. To the point of being rude. To the point of being obnoxious. To the point of being harassing to the staff of CPS. I heard that time and time again. It doesn't mean that they're innocent or whatever. Hi, KTZ. But I'm just explaining that this type of behavior would not reflect well in a CPS case, because they will get a hold of you. They found the kids. Someone at the hospital either reported it. There was an incident where the children... what that tells me, and I'm just deducing this from what we've heard. All I know is what you know. We've just heard it together. Both children were at some point both in the hospital or at a hospital and drew the attention of somebody who called CPS, who came to that hospital, and ostensibly she thinks they didn't do an investigation. They did an investigation, and then they removed the children from her. Yeah, concerning. Now, what I will say is that it's not unlikely, or it's not untrue that CPS sometimes removes children, and then if they're placed somewhere safe with family, biological family, that things can calm down a little bit. But you still should be following a service plan if your children have been removed from your care.
But nobody from CPS.
Have you filed anything with the court in an attempt to get your children returned?
No, because I was waiting on the ruling and paperwork from CPS. And I've been in constant contact with the father of my children since then. So I don't know.
I'll pass
He
the
never
witness,
said
Judge.
about
Have you
this.
seen the children since June of last year?
I have,
Always supervised by their dad?
yes.
Okay. And you didn't go to a CPS office and demand that somebody talk to you?
They said I couldn't come up there without an appointment. That's
Okay.
what they told me on the
Did you
phone.
go up there and make an appointment?
I had to do it over the phone.
Well, did you make appointments?
I tried, but they were saying because I didn't have my case number, I couldn't go up there because I didn't know who to talk to.
Okay, so when you were on the phone with them, did you ask them for your case number?
Yes, and they couldn't give it to me because they didn't. For some reason,
They can mail it to you, ma'am. They might not be able to give it to you over the phone.
they said they mailed it already, and I don't know where they mailed it to.
Then you
And they
should have asked them to remail it.
Yeah, we did, and I've been waiting for it in the mail, but nothing had to came.
You've been waiting for it in the mail since fucking July? Now, granted, I am still waiting for some things to come in the mail from Christmas. But is this a joke? The CPS case said neglectful supervision. I'm getting those vibes. Allegedly, in my opinion. Just her outfit to court, ma'am. I'm dressed better than you. Like, what are you fucking wearing? Do you know, if this was your chance, if you say you were so worried about your kids and you were calling and you were looking it up and you were trying to follow up, do you not think that the time you get to stand in front of a judge, you would be fucking dressed with your proper outfit, sitting up straight, absolutely engaging properly? This is not a fucking FaceTime with your friends. Oh, I'm mad now. It's gotten me mad. Ridiculous.
Yeah.
Okay, well.
I gave them the
Because
address.
of their findings and I don't know what efforts you made, but all I can say, if somebody took my kids, I'd bother them every day. And I'd be at their office, even if they told me I couldn't be at their office, because they'd have to tell me something. Okay? So I'm going to find Dad to be sole managing conservator, you to be possessory conservator, make a finding of family violence, supervised visitation from 11 a.m. to 1 p.m. on the first, third, and fifth Saturdays of each month. Mr. Talley, the only thing I didn't get is the location of the visitation.
It is a McDonald's at 17250 Preston Road in Dallas.
Okay. At the McDonald's at 17250 Preston Road in Dallas, Texas. That visitation will be supervised by Mr. Crook, by Miss Nave's mother, or any adult individual that Mr. Crook deems reliable. Dad will maintain government health insurance on the children. Mom will pay cash medical support of $50 each month, pay child support of $275 each month. There'll be a child support judgment after possession credits against Mr. Crook in the amount of $6,456.76. That judgment will be paid at $80 per month. There'll be a medical support judgment after possession credits of $2,141.19. That judgment will be paid at $35 per month. Court costs as billed. All start dates will be June 1st, 2025, and the non-disclosure is granted. Does anyone have any questions?
I
Yes,
do.
Mr. Crook.
So my last like on page 4 of my like the of my child support, it said I had a history of family violence, which I did not have at all.
Mm-hmm.
I never went to jail on the family violence at all, and I was trying to see if you can remove that off of the case,
I
please.
can't remove it off of that order. That
Okay.
order is that order. And now we're going by this order.
Okay.
This order has family violence against Miss Nave. It does not report
Okay.
any family violence
I just
against
wanted to
you.
make sure. Thank you.
Okay. Any other questions?
What family violence is it because of the CPS case?
Yes, ma'am.
Okay. That's a history. But that's not a history though.
So it's not a history.
Is that your mama? Is that your mom or your friend coaching you that couldn't tell you to put something the fuck on before you got on your goddamn court case? Seriously, are you telling me that two grown woman adults sat there and thought that that was a good idea to wear to court? No, folks. No. No.
But it's egregious enough for it to be a family violence finding. And I don't know who's in the room with you telling you what to say and what to ask, but if they're not an attorney, you should not be listening to them. Okay? Now that I've made my ruling, I'm not the last word on this. This is out of the 255th District Court. Okay? Now that I've made my ruling, I'm not the last word on this. This is out of the 255th District Court. That is Judge Vonda Bailey.
Did you see her fucking face? Oh, go in front of Judge Vonda Bailey. Please. Please appeal this to Judge Vonda Bailey. Do it. Oh, I would love it. Did you see her face though? There's that moment where she did the fake smile and then the contempt. The absolute contempt for the judge, giving her real advice, which is, hey, dumbass, the even stupider dumbass that's in the room with you right now is definitely not a lawyer. Because if they were, they would have made an appearance. But you shouldn't be listening to them. Like, oh my God. Thank God for their dad. Thank God for their dad. Also, let this be a good lesson, you know. It's not just gender that decides who parents children. It is actions. And her actions or lack of actions speak louder than words.
She might have a different opinion from mine. So you have 3 days to appeal, 30 days to file a motion for new trial. Now that I've given you that information, does anyone have any questions?
No, ma'am.
Ms. Nave, do
Okay.
you have any questions? All right,
No.
then thank you for appearing here today, and you're
Sorry,
free
Judge.
to go.
I do have one question regarding clarification on your ruling.
Okay.
I wanted to see if this was a miscommunication or if you were ordering something other than what was proposed on the payout on the child support judgment. 60 was proposed, but you ruled 80.
Oh, no, Mr. It was a miscommunication, Mr. Tally. I don't know why I thought I heard 80. Okay, so then that'll be $60 per month instead of $80 per month.
Thank you, Judge.
Thank you, Mr. Tally.
Thanks.
You see how delicately Mr. Tally put that to the judge? So great. I believe there was miscommunication. So smart. I love it. All right, let's watch I think one more. I think there's one more.
All right. If there are no further questions, then everyone is free to go.
Thank you.
Judge, I need to make a couple of room assignments and then I've got some service on the records we can do, okay?
Okay, sir. Yours real quickly.
Yes, Judge, it's
Is
number
yours?
5 to room 4.
Not an interpreter case. No. 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 Oh, good. It was just service on the record. And then how do we say this lady's name? Holy fuck. I can't even begin to say it in my head.
David John Burnett.
Do you need a Spanish interpreter person's name on your case?
David John Burnett.
Do you need a Spanish interpreter?
Yes, please.
Okay, let me get her renamed, Judge.
It's coming
And you
out.
can go ahead and mute, Ms. Gonzalez. Silencio, por favor.
Silencia, por favor.
Judge, Ms. Peoples is ready to approach, okay?
Yes, sir.
Judge, I'm ready on number 35.
We're hearing cause number DF 24180338, Foley and Ferguson. With the parties in the Foley matter, please unmute yourselves, turn your cameras on, and raise your right hands. Do each of you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Ms. Ferguson?
Yes, ma'am, I do.
Mr. Foley?
Yes, ma'am.
You may both lower your hands. Ms. Peoples, you may proceed.
Thank you, Judge. I'll first need to call both parties for service on the record.
You may.
If I can start with the mother. Ma'am, can you state your full name?
Beashlyn Bonnier Ferguson.
Ms. Ferguson, did you receive an email from our office containing the petition that was filed in your case?
Yes, ma'am, I did.
And do you understand that you have a right to be personally served with that petition?
Yes, ma'am, I do.
Are you in agreement to waive personal service and make your general appearance in the case today?
Yes, ma'am.
Do you also understand that you have the right to request a reset for your answer period to pass?
Yes, ma'am, I do.
Are you in agreement to waive your answer period and proceed today with the court order?
Yes, I do.
I'll pass the witness, Judge, and ask that the record reflect Ms. Ferguson has agreed to waive service.
The record will so reflect.
Thank you, Judge. If I could also call the father for service.
You may.
Mr. Foley, can you state your full name?
Rashid Ahmad Ali Foley.
Did you receive an email containing the petition that was filed in your case today?
Yes, ma'am.
Do you understand that you have a right to be personally served with that petition?
Yes, ma'am.
Are you in agreement to waive personal service and to make your general appearance in the case today?
Yes, ma'am.
And do you understand that you also have a right to request a reset for your answer time to pass?
Yes, ma'am.
Are you in agreement to waive your answer period and proceed with an order today?
Yes.
Okay. I'll pass the witness, Judge, and ask that the record reflect that Mr. Foley has waived service.
The record will so reflect.
Thank you, Judge. Judge, we're here on an order in suit affecting the parent-child relationship. We have an agreement as to all issues except for the visitation and retroactive child support. If I could read the proposed order and then take testimony on the non-agreed issues.
You may.
Thank you, Judge. Judge, there are 4 children before the court. Miracle, Michaela, Richland, and Rashid Foley. Judge, parties are currently married. The children were born within the marriage. Parties are in agreement to be appointed as joint managing conservators of the children, with the mother having the right to maintain the residence within Dallas County. Judge, the proposed order does have a family violence finding with supervised visitation, which I'll take testimony on. There's 4 children before the court. Mr. Foley does have 1 other child for which he's ordered to pay support. So his child support obligation is set at 32.2%. Parties agree the mother is to apply for or maintain government medical for the children. Mr. Foley is to pay cash medical support of $220 a month beginning June 1st, 2025. Child support judge for the 4 children would be $775 a month beginning June 1st, 2025. And there is a retroactive child support judgment of $3,100 to be paid at $66 a month beginning June 1st, 2025. Court costs will be as billed to Mr. Foley. There is a non-disclosure request for the mother's address and information, and that is the extent of the order, Judge.
What's the payout on the judgment?
That's the payout is $66 a month.
And the judgment is $3,100, right?
Yes, Judge.
Okay. And 66. Okay.
If I could recall Ms. Ferguson. Ma'am, did you hear all the terms of the order that were stated to the court?
Yes, ma'am.
And did you understand all of those terms?
Yes, I do.
Okay. You're in agreement with all the terms and believe they're in the best interest of the children?
Yes, ma'am.
Okay. As far as your relationship with Mr. Foley, has there been any family violence between the two of you all in the past 2 years?
For the kids, yes.
Okay, so there was abuse for the children and Mr. Foley?
Yes. I have a piece of a paper, a family plan that he's supposed to have supervised visits with the kids.
Okay, so when did the incident occur?
Last year.
Do you remember the month?
No, ma'am, I do not.
Okay.
The paper do not, it don't say that. It just says what they expect of me and Mr. Foley.
Okay. And so you said he used to have supervised visits. Was CPS involved?
Yes, ma'am.
And CPS gave Mr. Foley supervised visits?
Yes, ma'am.
Okay. What can you tell the court what happened?
My daughter went to school. My daughter that has autism, and says that her dad got mad at her and slapped her in her face. And my other kids that's not by him basically said that it was true. And so we have to follow out through a family plan. And I'm not allowed to supervise the visits. He has to have supervised visits, and he's not allowed to spend the night or anything else.
Okay. And so aside from that instance, have there been other instances of family violence between Mr. Foley and the children?
No.
Okay. And had there been any between you and Mr. Foley?
Mentally and emotionally, that's it. Not physically, no.
Okay. Do you know how long those supervised visits are supposed to last?
When the case closed, she said I just have to follow up through the plan. It says I'm just supposed to continue to be protective over my children, and then I'm supposed to learn about domestic violence. It don't even say how long it's supposed to be in place.
Okay.
It just says, huh? Yes.
No, go ahead.
It just said Mr. Foley is to be supervised at all times when visiting the children. He is not allowed to live in the home or have overnight stays. Miss Ferguson is not allowed to supervise the visit. That's all it says.
Who is supervising the visits?
He don't feed the kids.
Okay, so he hasn't had any visits with the children since this happened?
He has a visit at the park. We went to a public park, and they went to his house where his mom at for a day, and then they came back. That was like in January, February.
Miss Ferguson, I don't know who you're talking to or who you're looking to for confirmation.
I'm thinking of the date.
Okay.
Now.
You keep looking over that way, and you're making me believe there's somebody in the room with you.
I was looking at the papers that I have on the side.
Okay. Okay.
Other than that, then no.
Oh, man, this is winning.
So, Ms. Ferguson, what are you requesting? Are you asking that Mr. Foley continue to have supervised visits going forward?
Yes, ma'am.
Okay. Who do you want to supervise those visits?
His mom or his sister.
Are you in agreement with him? Does he live with his mom and his sister?
He lives with his mom that I know of.
Okay, so you're in agreement with him having standard visitations, which would include overnight visits, but you want those to be supervised by his mom or sister.
Yes, ma'am.
Okay. You're in agreement that the two of you would be appointed as joint managing conservators of the children?
Yes, ma'am.
And as far as the child support and medical support amounts, you agree with those amounts that were stated as well, correct?
Yes, ma'am.
Okay. And you're requesting retroactive or back child support from February 1st, 2025 to today, May 16th, 2025, correct?
Yes, ma'am.
And y'all didn't live together during that time period.
No, ma'am.
And has he or did he provide any type of financial support for the children during that time period?
Yes, ma'am. Pull-ups and wipes.
Say that one more time, Ms. Ferguson.
Pull-ups and wipes.
Okay. And aside from that, did he give you any other money for the
No,
children?
ma'am. No, he has not.
And so you're asking the court to confirm that retroactive judgment of $3,100, correct?
Yes, ma'am.
And you're asking that he be ordered to pay that at $66 a month.
Yes, ma'am.
As far as your address, you're also requesting a non-disclosure today.
Yes, ma'am.
Why are you asking that your address not be in the court order?
Because I do not feel comfortable with him knowing where I live at.
Does he currently know where you live?
No, ma'am.
So as far as the visitation, how are the children exchanged? Are you dropping them off at his house?
I can meet in a public place, or I can drop them off. I do know where his mom stayed.
Okay, are you wanting to meet at his mother's house?
Yes, ma'am.
Is there any other reasons or anything else you want the court to know as far as your request for a non-disclosure?
No, ma'am.
I'll pass the witness.
Ms. Ferguson, has there been some family violence between you and Mr. Foley?
In the past, I done
Can you
called the
say,
police.
Mr. Foley, right now, I'm just talking to Ms. Ferguson. If you can't refrain from talking, mute yourself, sir. Ms. Ferguson, when was the last time there was some family violence?
Some years ago, maybe 2020.
How many years ago?
2020.
Okay, but there's been nothing since 2020.
No, ma'am, only with the kids.
Okay, and with the kids, it was that one incident.
Yes, ma'am.
Okay, thank you. You may proceed, Ms.
Thank you, Judge. I'll recall Mr. Foley. Mr. Foley, did you hear all the terms of the order I just stated to the court?
Yes, ma'am.
And did you understand all those terms?
Yes, I understand.
Okay, and so you, with the exception of the visitation and the retroactive child support, you agree with all the other terms, correct?
Yes, ma'am.
Okay, and so you disagree with having supervised visits?
Yes, ma'am.
Okay, can you tell you're requesting just unsupervised standard visitation?
Yes, ma'am.
Can you tell the court why you disagree with the supervised visits?
Because I have no background of me doing any harm to my child. The CPS cases was open. They closed the cases, but somehow they put me on there as I did something to my child with no physical proof. And then with the order that was in place for the supervised visits, she had a recent CPS case that was just open. She had custody of her niece. Her niece ran away. The CPS worker called me and said he had no issue with me, no problem. He talked to Miracle and Michaela, and I asked him about the supervised visit thing. He was like, long as CPS case was closed, I can go see my kids. And
okay, so hold on, Mr. Foley. To your knowledge, the CPS case is currently closed.
The recent one that was just open, the recent case that was just open, it was because her niece had ran away from her.
Okay, well, we're talking about the case that was open because of your daughter.
That case closed. That case closed last year.
Okay, so to your knowledge, you don't the supervised visitation through CPS.
I don't have supervised visits. I never been court ordered supervised visits or anything. This is something that they had in plan while the CPS case was open. That's not a full thing or anything like that.
Okay, so has there been any family violence between you and Ms. Ferguson in the past 2 years?
Not in the past 2 years, but she did tase me, and she has a ticket for that.
And when was that?
2020?
Okay. Has there been any family violence with you and the children other than that incident in
No,
last year?
I don't know. There's nothing documented of any family violence between me or my kids. Nothing at all.
Okay. Were any criminal charges filed against you for what the incident with your daughter?
Nothing at all.
And so you're requesting that you have standard overnight visits unsupervised.
Yes, ma'am.
Okay. Do you live with your mother?
Yes, ma'am, I do.
Okay. And then as far as the retroactive or back child support judgment, you don't agree with any retroactive child support being ordered today. Is that correct?
No, ma'am, I don't.
Okay. Have you provided any financial support to Ms. Ferguson
Yes, ma'am.
between February 1st
Yes, ma'am, I
and
have,
today?
and I also have a witness that can contest to it.
Okay. How much money did you provide in support to Ms. Ferguson?
I didn't provide any money, but the things that she said they needed, I provided.
Okay. And what kind of things did you provide?
The only thing she's asked me for is pull-ups and wipes. And she asked me for a toilet bed and clothes, but I'm waiting on them. Because the one that I wanted for Rashid, the toilet bed is not in stock. And their clothes, I'm waiting on the refund so I can go to Children's Place and buy their clothes. But everything that she's asked me to do, I've done.
Okay, so aside from the pull-ups and wipes, what else did you provide?
She didn't ask me for anything else, so that's all I provided.
So you're asking that it be $0 for back child support?
Yeah, and we separated in February. We didn't separate January.
Okay, yes, you understand the judgment date is February 1st, 2025 until today.
Okay, yeah, that's right.
You understand court costs today will be billed to you through the Dallas County District Clerk's office?
Yes, ma'am, I know that.
All right. Do you have safety concerns with your address being in the order?
No, ma'am.
All right. I'll pass the witness.
Mr. Foley, you say you provided diapers and wipes. What monetary value do you give that?
I don't know because like I say, what she asked me for, I give. I don't know what they need unless she tells me.
Okay. It's not what I asked you. What I asked you was how much money did you spend on diapers and wipes?
I have to go look. I don't know. I have to go look at it.
Did you buy diapers and wipes every week? Did you buy diapers and wipes once a month?
I can't recall. I have to go look. I have to go actually look at the app to be sure to tell you.
How many kids did you buy diapers and wipes for?
It's only for Rashid and Rasha.
Rashid and Rasha?
Yes, ma'am.
Okay. And there are 4 kids total. You have 4 kids with her total?
Yes, ma'am.
And what are their ages?
Miracle is 6, Michaela is 5, the twins are 4.
Okay, thank you. Miss Ferguson.
Yes, ma'am.
Is the CPS case closed?
Yes, ma'am, it is.
And those findings about supervision, were those before it was closed, while it was pending?
It was before it was closed, and the caseworker told me to keep it in plan while it was closed. It's just a safety plan that she wanted me to keep when the case was closed.
Okay, you have something saying that it's supposed to go on now?
Yes. It don't have a specific date, but yes, I just have papers of the safety plan.
Okay, so this is what I'm gonna do. I'm gonna accept the agreed portions of the order, make the agreed portions the order of the court. I'm gonna order standard visitation supervised by Mr. Foley's mom or his sister for the next 6 months. After that, it'll just be standard.
Yes, ma'am.
Okay. And the non-disclosure is denied. Ms. Peoples, is there anything else I needed to rule on?
There's the retroactive child support.
Oh, the retroactive child support. Mr. Foley, you're not giving me enough information, so I have to go with the $3,100, sir. Is that how much it was, Ms. Peoples? Oh.
Yes, Judge, $3,100.
Okay, because you're not giving me enough information to give you credit for what you did. Okay. And that judgment will be paid at $66 per month. Anything further, Ms. Peoples?
No, Your Honor. Any
questions from either one of you?
How do I appeal or contest this and get an attorney?
Hold on one second. I'm gonna tell you that in just a second.
That's exactly what I'm waiting for.
So you don't agree with my ruling. You have 3 days to appeal, 30 days to file a motion for new trial. This is out of the 330th District Court. That's Judge Andra Plumley. She might have a different opinion of mine. That's who you'd appeal to. The Attorney General's office can email you the instructions on how to appeal. Now that I've given you that information, does anyone else have any questions?
No, none at all.
All right, then thank you both for appearing here today, and you're both free to go.
Judge, I need to do a couple of room assignments and then I'll be ready to approach on something, okay?
Assign my room,
Okay.
Brian.
Jarshawn Brown, you've been invited to room 1. Please join the breakout room. Jarshawn Brown, please join the breakout room. And then Monica Davis, I'm moving you to room 5 to speak with Alina Peoples with the Attorney General's office. You won't receive a new invite. Look on your device for 4 squares or dots in the words join breakout room and click on that. That will take you to room 5.
Excuse me. I don't know if I was told to go into a breakout room, but Talk Ladas, he's been in one. I don't know if I was kicked out or something.
I have not made an announcement or sent you an invite.
Okay, thank you.
Okay, Judge, I'm ready to approach on number 8. We have both parties present for service on the record.
Judge, I am also ready on number 18.
Hold on one
Let's
second,
see what else
Mr.
we
Taylor.
have before we
Should
say
probably check with
goodnight.
Mr. Burke and make sure it's okay that I approach on
Oh,
that.
we're just saying goodbye.
Absolutely.
I have a surprise.
It's all yours,
for
Mr.
you.
Talley.
But the day is going quickly, so I can't be too good. Come on, Mr. Talley, hurry the fuck up. Oh, no, we already watched this. Never mind. That was the end. Perfect. Because remember, we watched that guy, so that's it. The good news is I'll be back later for members only. Yeah, that's right. What? Members only? That's right. Members only. So, keep an eye out for that. I don't know what time yet. I have to go to the grocery store. I have to basically clean my entire house. But I'm not going to do all that first. Probably earlier. I think we'll do it earlier rather than later. So think, I don't know, 4:20, like an hour. Give me an hour. I'll tidy the kitchen, load the dishwasher, change the laundry, then we'll be back for members only. I'll be naked under my clothes. And then you can be naked at home. And then we will reconvene here. Live at 7:30, which is what, 4:30? Okay, good to remember. Maybe I'll do it earlier. So much to think about. So many things to do. Oh, also everyone be safe. I saw Ryan Hall, y'all, is live. That always concerns me. Be good. Well, maybe we'll do it later and I'll just go grocery shopping first. Anyways, I love you guys so much. Do me a favor, remember that. Remember that I love you and I'm proud of you. And I will see you in the next video. Okay, bye.
Always down and ready to ride.